One measure before us today, and we have one member, Senator Anderson, who will not be at the meeting. Senator Gaines removed his SB 171 yesterday, and SB 202 will be a new bill for this year. So we only have one bill, and that is Senator Block's SB 617. So, Senator Block, welcome to the committee.
Thank you, Madam Chair.
Oh, we're going to, since we do have a full house here, I think, just about, let's take the roll.
Hancock,
Here.
Anderson, Glazer, Leno, Lou, Monning, Stone.
Okay. And could you just call the roll again? Oh, Glazer, here. Okay, good. Good. Senator Block, present.
Thank you, Madam Chair. Pleased to be back. Good to see you all again. We often hear that too many resources and too much time is being sometimes wasted in our criminal justice system prosecuting very minor misdemeanors. Some things that are often charged as misdemeanors and that put people in the criminal justice system really shouldn't be bringing people into the criminal justice system. For example, one crime that my bill, SB 617, would impact is the crime of illegal lodging, where people who are homeless can be arrested for homelessness, basically then be charged with illegal lodging, which is a misdemeanor, be put through the criminal justice system, have that on their record. My bill, SB 617, among other things, would make that, or at least give the defendant an option to have that heard as an infraction as opposed to a misdemeanor. When I say have it heard, it wouldn't even be heard. It would just be like a traffic fine then that is paid and that there is no trial, there is no criminal record. SB 716 authorizes county prosecutors to reduce certain non-serious misdemeanors, including what was just mentioned, if they deem that to be in the county's best interest, reduce them to infractions. The bill excludes serious misdemeanors, including those involving sex crimes, child abuse, elder abuse, domestic violence, DUI, and any offense involving a firearm. The last page of the bill, it's a brief bill, just lists those offenses that are excluded from SB 617. The measure aims to focus resources of the district attorney and our criminal justice system on individuals who should be in the criminal justice system, and to exclude those who can safely be held accountable for their offenses, which are minor, without incarceration but through fine. Since the last time the bill was heard, there have been many amendments that will address many of the concerns of the committee. First of all, a major concern was fines and people who may choose to have their cases handled as infractions and then confront very large fines. We've capped the fines in SB 617 for infractions that are tried under this provision to $250 as a maximum. For those infractions where there might be a lesser fine already provided, it would be the lesser fine. So $250 would be the max. Person charged with an infraction will be notified and will have the right to have the charge elevated to a misdemeanor, and that would include the right to counsel in the misdemeanor stage if they decide to. So it's up to the person who's charged. If the district attorney says we want to reduce it to an infraction, but the accused would rather have it heard as a misdemeanor, I think that would be rather rare. But if that were the case, they would have a right to have it heard as a misdemeanor, have their full day in court, full trial with counsel. Courts are currently spending about $500 million per year to administer misdemeanors, and according to the LAO, the average cost of processing a misdemeanor is about 10 times as much as the average cost for an infraction. So we are talking about a cost savings here, but to me the most important part is sparing people who are charged with minor disorderly conduct, charged with minor harassing phone calls, charged with homelessness, so that's not the charge, to save them from being part of the criminal justice system and for having the future damage to their employment possibilities and everything else to become part of being involved in the criminal justice system by having them heard as infractions. SB 617 is an important measure. It continues, I think, the governor's efforts to make sure that punishment fits the crime and to hold violators of minor offenses accountable, but still keeping them out of the criminal justice system. It allows courts and local prosecutors to direct their energy and resources to the most dangerous individuals. It's sponsored by the San Diego District Attorney's Office, Bonnie Dumanis, and is supported by the County of San Diego. With me here today is Laura Solov, the Deputy District Attorney from San Diego, who handles these types of cases. She's here to answer any questions and to testify. And I will ask you for an aye vote.
Thank you. It's Rachel Solov, but that's okay.
Rachel.
Laura Tanny was here last time, so I can see the confusion. As the senator said, my name is Rachel Solov, and I'm here on behalf of my boss, San Diego County District Attorney Bonnie Dumanis, who's the sponsor of this bill. I am the chief of the Collaborative Courts and Realignment Unit in our office. In that, our responsibilities are implementing and running the drug courts, reentry courts, veterans treatment court, behavioral health court, mandatory supervision court, homeless court, the post-release community supervision, and parole revocation courts. And we are also involved in the processing of the Prop 47 petitions. And I share that with you to hopefully let you see that I come from the trenches in what we're dealing with right now. We are actively working to reduce recidivism through rehabilitation and re-entry into the community. What we are seeing, though, is that, as you know, this takes a tremendous amount of resources. SB 617 will help free up some of these resources so that we can focus on the high-risk, high-needs misdemeanors that we are now having to deal with as a result of Proposition 47. These individuals used to be felons prior to Prop 47, and now they're misdemeanors. They have higher needs that we need to address. We are struggling in the trenches right now to deal with this population because the finances are not there. And in looking at the governor's budget summary, it doesn't look like the estimated savings from Prop 47 are going to provide us with a lot of resources. So making a change like this will really help us to provide the services and the needs to the people that should be treated as misdemeanants and given the resources, and help us get out the people that don't need those services, help get them out of the criminal justice system. What we have seen in San Diego County is that the increase in misdemeanor trials since Prop 47 went into effect, as opposed to prior to Prop 47, greatly outweighed the decrease in felony trials. So we're actually doing more jury trials than we were doing prior to Proposition 47. That costs the court money, it costs the prosecution money, it costs the defense money. It really taxes the whole criminal justice system. So this bill will allow us to remove a lot of the people out of the system that don't need to be here. I was not here at the last hearing, though I watched the hearing, and I know there were a lot of concerns about the fines, which we've addressed by reducing it to $250 so that it's consistent with other current infractions. I am happy to answer any questions on the process of infractions in court and some of the other consequences and concerns that you may have. If you'd like to direct my attention to something, I could probably better make use of the time.
Thank you. So if you stay right here, we're going to hear speakers in support, speakers in opposition, and then I think we can have a more informed conversation. Thank you. Speakers in support of the bill.
Andrew Langley on behalf of the County of San Diego in support. Thank you.
Thank you. Others in support? Speakers in opposition to the bill?
I'm sorry, still in support.
Okay, good.
Chad Andrews on behalf of the CCLA in support.
What is the CCLA?
The California Civil Liberties Advocacy.
California Civil Liberties
Advocacy.
Advocacy. Okay.
Thank you.
You can speak in support.
Opposition to the bill. Okay. Two witnesses.
Sure. Madam Chair and members, Khalif Asagai on behalf of the California Public Defenders Association. It's great to be back with you today. We appreciate the amendments that were taken by the author and the hard work of the staff during the interim. We do think this is an improved bill. especially in that it reduced the fees down to $250, which was one of the suggestions in our original opposed letter. Our concern remains that in making the decision, for defendants making the decision as to whether to be charged as, have their crime charged as an infraction or a misdemeanor, they will not have the aid of counsel. There are going to be collateral consequences, whether it's an infraction or a misdemeanor. And what we would like to see is a mechanism by which the individual who's making this decision would have the right to consult with counsel. This could be that if somebody elects, in order to be advised by counsel, a misdemeanor, that if the defense counsel says to that person, this would be better charged as an infraction, they would be able to then reduce it back down to an infraction. You really can't have informed consent on these decisions without the guiding hand of counsel, and we just want to see that protected under this legislation.
Thank you.
Thank you.
Madam Chair, members, Dan Filisato on behalf of the Los Angeles County District Attorney's Office. We are regrettably opposed to the bill at this time. We have concerns about ensuring that only the prosecutor, the district attorney, has the ability to decide whether or not a crime should be punished as a misdemeanor or an infraction. We also have concerns about excluding consumer, environmental, workplace safety offenses because of the important nature of these crimes, but they are 6-month misdemeanors in many cases. But we've been working with the San Diego District Attorney's Office, and we'll continue to work with them to address our concerns. So, like I say, regrettably, at this time we're opposed, but like I said, we would like to continue to work with the author and the sponsors on this. I think we can address this. Thank you.
Thank you. Are there others in opposition to the bill? Okay, seeing and hearing none, I'd just appreciate it if you guys could stick around, all of us, because, you know, I find the goal of this legislation to be laudable, really. And I'm glad that it came forward. The more we can concentrate our criminal justice resources on the most egregious cases, the more we can spare people from getting really entangled in a criminal justice system that does not appear to be rehabilitating them very well at this point, the better off we're going to be. However, I do think the issues raised by the opposition are extremely important and really central to our criminal justice system. Now, I read the bill as retaining judicial discretion in addition to prosecutorial discretion. Am I wrong about that? Does it take away the current ability of a judge to reduce a misdemeanor to an infraction? Well,
the current version of the bill does not provide for judicial discretion. It's simply the charging function as opposed to judicial discretion. And these are some of the conversations that we've had and some of the recent changes that we've made to the bill. It's our interpretation that it does not provide for judicial discretion.
okay.
But these
that
are
is the
ongoing
problem for me.
conversations with LA.
That is the problem for me, I think. So just flagging that. I actually wasn't sure. I thought it might still be retained after looking at some of the language. Okay. On that topic, Senator Monning?
On that topic, on the judicial discretion, as I read it also, it's the charging district attorney who offers the prospect of a defendant choosing infraction over misdemeanor. If it goes through a misdemeanor prosecution at the time of sentencing, does the judge have the discretion to impose the penalty associated with an infraction, even if it's gone through a misdemeanor prosecution?
No, let me answer that question in two parts. First of all, the process with an infraction right now, there are crimes in the penal code already that the district attorney or the city attorney, the prosecutor's agency, has the ability to charge as an infraction that don't have the judicial discretion part to it. What happens is that the defendant, even when they're charged with an infraction, is still given a date to appear in court and arraigned in front of a judge on that infraction. So it's not entirely the district attorney or the prosecutor's agency that is providing them the information that they have the ability to elevate the crime to a misdemeanor. There is a hearing in front of a judge.
But my question goes to sentencing.
That's the second part.
Okay.
Okay. So the second part of that is no, this bill would not allow a judge to, at sentencing, then say, you've been found guilty of a misdemeanor, but I am now going to deem it an infraction. However, the judge has discretion at sentencing, even if it's a misdemeanor, to not impose custody and to impose whatever fine the judge deems reasonable, but it would not have the ability to, at that point, say, okay, this is an infraction.
It might mirror what would happen in an infraction. The penalty imposed, the judge could choose not to order incarceration and could impose a fine of $250.
That's correct. And standard misdemeanors, what we see in practice, even though misdemeanor code sections allow for a $1,000 fine, what we see in standard practice is that the fine the judges impose, at least in San Diego County, is $200 for misdemeanors.
Thank you.
Senator Leno had a question
So
on
on
this
that point,
topic.
thank you, Madam Chair. So you had made reference to the fact that there are now crimes which affords the prosecutor the authority to move forward either as infraction or as misdemeanor. We call them woblettes, right? So how would this operate differently from a woblette? You said in the woblette, the defendant always goes into a courtroom? And this is described would keep that person from the courtroom. That's one of the motivating factors for the bill altogether.
So, no, I mean, I think that ideally it would be great to provide an opportunity where if someone wanted to just pay a fine and treat it like a traffic ticket, they could. However, the way it works currently, for example, 490.1, which is petty theft under $50 for someone that has no prior.
Could be charged either way.
Can be charged either way.
And what is the, how does that unfold from there?
So what happens in that case is that the offender would be given a date to appear in court. They would come to court. They'd be arraigned in front of a judge on the infraction. They would not have counsel appointed. And this is one thing to talk about in terms of the right to counsel. We're not trying to take away the right to counsel. So the person still has the right to counsel. But what they don't have the right to is a counsel at taxpayer expenses to a public defender. So I think that is a slight distinction, not a determining factor. But we're not trying to deprive anybody of their right to counsel or any of their rights.
Under current law, if I'm charged, I go for the arraignment, at which time it will be determined that it will be prosecuted either as an infraction or a misdemeanor at the arraignment. That's current law.
Current law. So let's say, yeah, so.
And I would have access to a public defender if I qualified at that point.
Not if it's filed as an infraction, no. Current law, if you are charged with an infraction, the current law is that you are not entitled to court-appointed counsel. So if you were charged with this 490.1, for example, this shoplifting, you would come to court for your arraignment. The judge would arraign you on the charges and advise you that you had the right to elect to go forward at that point as a misdemeanor, and you could go from there.
And what you're proposing for this other category of crimes is that I wouldn't even go in for my arraignment. I would get something in the mail that says you are being charged with an infraction.
No, I think that was the initial thought process for it, but I don't think that that's where we are now.
So now it would mirror the current law.
It would mirror the current law, except for it would not be those crimes outlined in 19.8 that give judicial discretion. So you look at Penal Code Section 17D and read it in conjunction with Penal Code Section 19.8, and those are currently defined woblettes. But there are other crimes in the Penal Code section that are infractions that are not woblettes. Does that make sense? So this would just expand the number of crimes that we could charge as infractions, but they would still be entitled to go have an arraignment and be in front of a judge.
So as worthy as the suggestion of Mr. Assegai that someone would be able to come to court and have the benefit of counsel to determine which is a better way for that individual to go would actually be something new that the court's not doing now, providing a public defender
Correct.
in cases where they're not provided now, and would actually add to the current costs of operations.
Correct.
And I do say it is a worthy idea, but clearly part of the motivation for this bill is really to contain costs. In the entire presentation, we talked about the person, but as we heard from the LA District Attorney's Office, corporations could benefit from this. I can't imagine that was the intent of the bill. Why don't we add to the list of those crimes that are exempted from this benefit anything charged to a corporate entity?
We would not be opposed to that. We completely share in the concerns of the LADA's office of those crimes that are charged against corporations. We don't want to give them a way out, so we'd be in support of that.
Yeah, and in fact, in talking with the DA in San Diego, they would not recommend in any case that corporate crimes be reduced, but we can just exclude it from the statute altogether.
So I think that might be a good suggestion for the bill. Madam Chair, one more question, if I may.
Yeah.
Thank you. In practice, do we imagine that in more conservative parts of the state that the district attorney will, in many cases, continue to charge misdemeanors as misdemeanors, and in more progressive parts of the state, this new authority might lean more toward infraction, so it may not change status quo all that much? How do you think this will actually play out?
We can both address that, but I think
The reason I ask is I remember we had some data when we were considering the contents of Prop 47 as legislation, that the charging of simple possession of methamphetamine, different from cocaine or heroin, already had given, current law gave district attorneys the authority to charge as misdemeanor or as felony. And in some parts of the state, it almost was always a felony. In other parts of the state, it was almost always a misdemeanor. And in San Francisco, for example, it was half and half, right down the middle. So there were differences. I wonder if this would mirror that.
I can't speak to what all the DA's office would do across the state. I think San Diego is probably more on the conservative side than other parts of the state, and we're the ones that are bringing forward this bill. So if that provides any answer, and I think that obviously different offices have different policies in terms of how they charge things and what they consider. But you could see some offices that don't change their practice at all, and others that actually take advantage of it and trying to create savings to actually try and do some good for the people that need it.
And I'm sorry, one last question just popped into my head. If I could ask you, if you could imagine an unfortunate ramification of this, that I am without much education, I may not have much familiarity with the criminal justice system, I'm charged with one of these crimes, I get something in the mail. Oh, no, you say that doesn't happen anymore. I'm going to go in for my arraignment. I don't have counsel. I'm intimidated by, I'm nervous by, I'm overwhelmed by the whole atmosphere, and I've got to make a decision. Am I going to go one way or the other? What's the worst thing that you think might happen? And I'm just curious how you think. And I know that this would be the exception, not the rule. But what is at risk here if we were to go forward in terms of an injustice occurring?
I'm not aware of any collateral consequences to an offense such as this. There has been some discussion about potential immigration consequences. Immigration law is incredibly complex, and I'm not an expert in that. But in my experience, I have never seen a case where someone is deported for something that is an infraction. We're not talking about any drug possession crimes, okay? So any of the drug possession crimes are one-year misdemeanors, so they wouldn't qualify for this. theft crimes would qualify for this, certain theft crimes would qualify for this, but for example, the shoplifting, as I mentioned before, is already chargeable as an infraction. My understanding of immigration law, which as I stated, I'm not an expert in, is it primarily has to do with the amount of custody time that you do. And in fact, the legislature changed the law where a year sentence used to be 365 days, and now a year is actually 364 days, so that someone who gets a year in custody doesn't hit that magic 365-day number. In practice, in court all the time, we would have defense attorneys say, my guy will do a year in jail, but can you please make it 364 instead of 365 so it doesn't trigger immigration consequences? So because there's no custody imposed in an infraction, you wouldn't have those consequences. That's the only thing that could possibly enter my mind, and I'm not an expert in if there's other ways that someone is deportable through this, and I'm not aware of any, though.
Madam Chair, could I address that?
Oh, okay, fine. Then I'm going to ask if any of the other witnesses want to address it.
So I share the concern on immigration consequence, and it gets to an unsophisticated defendant being offered a choice of misdemeanor or infraction. We would intuit that the infraction would be the one people would opt for. But if when that choice is presented, you tell that unsophisticated defendant, maybe with an interpreter, that if they choose the misdemeanor path, they'll be entitled to an attorney. So they choose the misdemeanor path because they think I need the help of an attorney. Now they're in a misdemeanor path where if they are convicted, there can be an immigration consequence. You mentioned this distinction between 365 days and 364 days, but it could be a cumulative misdemeanor conviction where if the person had access to informed counsel, be that immigration counsel or even defense counsel, they would understand that opting for the infraction is in their better interest. But again, the unsophisticated person without advice of counsel thinks, if I go misdemeanor, then I'm going to have the support of counsel, and it could be against their immigration self-interest.
The irony of that, of course, Senator, is that under current law, 100% of these folks would face misdemeanors and have potentially their immigration status in jeopardy. This law will actually drastically reduce that number to hopefully, nearly zero, because I think most folks will choose the infraction. But indeed, if because of the idea of an attorney, some do choose the misdemeanor, that puts them in no worse position than under current law and puts everybody else in a better position. So,
Yeah, and I appreciate kind of that distinction, that there's a net gain by opening this door to infraction. Again, I do hold the concern of what level of advice people get. On the notice, will it be bilingual or multilingual when they come to that arraignment?
I would imagine that it would have to be.
So they preserve that right to interpreted proceedings even at that arraignment
Correct.
level.
And there's nothing in the way that this is written that triggers this mail notice or anything like that. So there's nothing in this that actually changes the way an infraction, the current process for an infraction is handled.
Thank you. Thank you, Madam Chair.
Okay. I would be interested in, Mr. Luzzatto, do you have a comment, and the public defender?
Sorry, Madam Chair. I am aware of one infraction that does trigger immigration consequence. When I was handling misdemeanor calendars, I was made aware by a defense counsel of basically, and I forget the code section, but it's a hit and run infraction. It's all of the same elements of hit and run, but it's simply punished as an infraction. And there were, when I became aware of that case, Los Angeles has lots of hit and runs. I would get some cases where I would determine, it is best to charge this particular case as an infraction, and would offer that to the defense attorney. There was one case where I thought, this would be a just sentence, and was informed by defense counsel that they couldn't take the plea because even though it was an infraction, since it had all of the elements of hit and run, that the federal immigration authorities still view that as a hit and run, even though it is punishable as an infraction, which is one of the concerns, like say our office has with some of the environmental consumers, is that the universe of 6-month misdemeanors is incredibly large and it goes across many code sections. That we want to make sure that we work with the author and the district attorney to identify all the potential crimes that we think should be excluded, but we're probably going to miss something, which is why we also want to ensure that that the district attorney has the sole discretion on whether or not the crime is punished as or proceeds as a misdemeanor or an infraction.
So does that allude to the issue of whether we keep in the judicial discretion that there is now?
Well, we don't believe that there is judicial discretion according to the sponsor. Our office would like to ensure that remains, and we're working with the sponsor.
What remains?
That-
Judicial
That there is no judicial discretion.
No, not in this bill, but in the current law.
In current law, there's only judicial discretion for the specific list of misdemeanors contained in, I think it's Penal Code Section 19.8. All other, today, if I'm prosecuting for somebody that's a 6-month misdemeanor, a judge has no authority to simply say, you know what, I've decided that this misdemeanor is an infraction and I'm reducing it to an infraction. They do not have that authority under existing law. However, when you create, what our concern is when you create a section like a 19.8 or in this bill, that the courts will start to interpret it even though the intent is not to have any judicial discretion. Kind of with things like with 3 strikes where the courts say, well, we have this inherent authority and we want to, now have this power. So that is one of our concerns. We've seen this in LA County. We implemented or the legislature implemented a pilot project that gave judges the authority to divert any misdemeanor. The intent, or at least the thought process, was that they would take, these kind of very low-level misdemeanor crimes that really are more of a nuisance than an actual crime. However, we've had several cases where we have our speed contest, where we have the individuals, close down the 110 freeway, and all those defendants wound up getting diverted, so their vehicles were never being able to be impounded and taken off the streets. So that's the concern that we have with this bill and why we want to work with the author.
Okay, I'm going to ask the public defender to comment on what would you call it, the unintended consequences.
Sure. First of all, I think we do share the goal of this legislation, which is to reduce contact with the criminal justice system and to make it easier on individuals to go through that system. I would say that there is an issue here of the fact that in this case, an individual has to elect whether or not they want to be charged as an infraction or a misdemeanor. And as Senator Monning pointed out, while somebody could elect to be charged as a misdemeanor, and then in order to retain counsel, if that counsel then says to them, this would have been better off as an infraction, they don't have a mechanism to go back down. That's one thing. Second, with respect to the collateral consequences, in 19.8, which already allows for misdemeanors to be charged as infractions, there's also a specific protection that reads, except for the violations enumerated in subdivision D of section 13202.5 of the Vehicle Code and a few others, that this crime is not grounds for the suspension, revocation, or denial of a license or the revocation of probation or parole for a convicted person. And so those are the collateral consequences that could be associated with pleading to an infraction, or I should say electing to be charged as an infraction under this particular scheme. So those protections being included in this bill would be helpful moving in the right direction. The other concern is that the unsophisticated person who chooses the infraction may not realize that the fees adding up to a certain amount and their failure to pay those fees could lead to additional consequences in the future, which may include actual incarceration for failure to appear or failure to pay. And so there is an opportunity, despite the fact that this bill does not allow for incarceration on the infraction, that the kind of outcome could still be that this unsophisticated person without the ability to pay ends up serving time because of that inability to pay. That was a concern that we have there.